Hi, Grad Dragons. So welcome back to my den. So we're going to talk about now psychological assessments and some of the issues you might run into when you start using assessments and you're testifying in court. And some of the ways the court system deals with assessment issues from our end. So forensic psychologists and psychologists of all types, clinical psychologists, research psychologists, etc., are part of everything that goes on in the court system, whether it's trial consulting or expert testimony or psych evals, testifying about parental rights, assessments, and things like that. It's also true in no matter what kind of court you are, whether you're in a muni court, criminal court, civil court, probate court, whatever. So they're present everywhere. So you have to understand what evidence you're using and how that evidence is admitted or not admitted in court, okay? So, so psychological testimony was first based on the Frye Rule, and that comes from Frye versus the United States in 1923. And they looked at evidence when is evidence admissible, okay? So under the Frye Rule, the evidence was admissible if the technique that they were relying upon was generally accepted as reliable by the organization, so American Psychological Association or the American Psychological Society. If that is relevant in that scientific community, then that was good enough for the court, and the circuit court affirmed this in the court's trial decision for expert testimony. And that was a lie detector test. Now we know that lie detectors are inadmissible in court today, and they have fallen out of favor with the scientific relevance in the field. Okay. However, that doesn't stop a lot of places from still using it. But if they wanted to do it, if they wanted to try and admit it for evidence, they can't. So one of the tricks that they use in the courtroom is to say, well, they passed a lie detector test, and the judge will say, strike that from the evidence. Okay, or they failed a lie detector test. Strike that from the evidence because it's inadmissible. But the seed has already been planted, so say that's what they do. But I don't even want to get into the whole lie detector controversy because it makes me insane. So we'll just leave that alone for right now. It's not a pretty thing. But in 1993, we saw an amendment for that, and that was in Daubert versus Merrill Dow Pharmaceutical Company. And the court said that Frye was not compatible and should not be used in federal court because it was not compatible with the federal rules of evidence. And so let's just go over the Daubert standard from the Cornell Law School. The definition is this standard is used by a trial judge to try and ascertain whether expert witness testimony is based on scientifically valid reasoning, and can we apply it to the case. So is it based, two prongs. Is it based on scientific reasoning and valid scientific reasoning? And two, can they apply it to the facts of the case? So that, again, I gave you the case citation. And under Daubert, you have to look at 4 different things to see if the methodology is correct. Both of those 2 prongs of that test. One, is the theory or technique in question something that can be tested? Okay, so they're asking about was it appropriate to do research on this phenomenon to begin with, okay? And again, you run into some issues because, again, judges and attorneys don't have to take research methods, and we know better in our training what can and can't be tested, and there you go. 2, has it been subject to peer review for publication? Peer review is very important. That's when you publish something somewhere before it gets published, or sometimes even after it gets published. Your peers at different areas, like if you publish it in a journal, then other professors or other people who are reading the journal, lawyers or something, will tear it apart, try and tell you what the shortcomings are and what some of the things you should avoid and things like that. So that's peer review, okay? So sometimes, most of the time, before it even gets published, it goes before a panel, a peer review panel. I've been part of those peer review panels, to see whether the methodology was correct, or the instrument was correct, or the generalizations were correct, or was the statistical tests that they were using correct, all of that sort of thing. Third, what is its known error rate? Does it fall within the standard margins of error in the statistical tests, which the court doesn't really understand, but they're relying on the peer review for that too. And for what are the existence and maintenance standards for controlling its operation? There's 5 parts of it. What are the standards for controlling its operation, like the applications and things like that? And 6, is 5, what is it widely accepted after this publication? So publication comes out, do people in the scientific community at large, not just the peer review panel, do they accept it as part of being relevant and valid for that community? So the Daubert standard is used in federal courts and some state courts. It replaced Frye, but Frye is still not accepted in every state. Okay, some states are still using Frye, and Daubert is explicitly omitted in Arizona, California, Florida, Nebraska, and New York. Explicitly rejected. Okay, so psychologists will be asked to state their opinions, and they will be asked to talk about reasonable scientific probability and certainty. Okay, so again, sometimes the difficulty is explaining basic scientific facts like statistical significance and probability theory to people who have never had to take that. So just keep that in mind, that can be very frustrating, and it's hard not to get sarcastic in the courtroom because it's very frustrating to try and explain that sometimes. So when you are looking for where you want to live, you've been offered a job in such and such state, okay, or area, you have to know the laws of that state, especially when it comes to evidence admissibility, especially if you're going to be put in a situation where you might have to testify often. So it's worth a check to see, what's going on in the court system there if you're going to be expected to work in it. There's no legal standing for a reasonable degree, like in a reasonable degree of certainty. Sometimes they mean more than 50% of the times, and sometimes they mean more than that. So again, you have to check that out. So the criteria for use in psychological testing and forensic assessments are 2 different things. The test should be commercially available and documented in 2 sources. So we have a publication compendium that usually psychologists, universities, researchers will get, and that's the big catalog that we pick the scientific tests, the assessment tools that we're going to use or we're going to teach in the case of a university. And only licensed psychologists can do that, and universities will operate through that professor, okay? And so this is why you get to use it, because you're operating under my aegis, and I'm overseeing this, and we're hoping that that's the way that goes. And that's the way it'll go in every kind of program. So if you go on to doctoral work and let's say you're going to do a clinical program because you want to do, let's say you want to do assessments all the time, you're going to have to work under the aegis of a licensed psychologist or under the university's, ability to monitor that. Okay, so it has to be actually documented in different cases, like in lawsuits or legal briefings or amicus briefs or things like that. Your favorite amicus briefs, or other publications. Okay, other research publications. So you have to have, the court also have to know how the assessment tool has been developed. What are the psychometric properties? If you go on for a doctorate, you will have to take at least 1 course, probably a lot more, in psychometrics. And that can be really difficult. I took several courses in psychometrics, and it never failed. It was always with a professor who had a deep accent, and it was difficult to understand those professors anyway. And how they administer the test. And sometimes they'll get into great detail about how do you score it? What does it mean? How do you get a decision from that? How do you make a diagnosis from that assessment tool? So all of those kinds of things. The listing and the reviews, over here in the notes that I gave you said it has to be in Mental Measurements Yearbook. Mental Measurements Yearbook is a really good source for what kind of assessment tools that are out there. But there are a lot of other ones now. There's that big compendium catalog that I told you about that we look through as well. And any journal of the American Psychological or American Psychiatric Association will have those, and they will vet them. So in terms of reliability, validity, and things like that. So that's what you have to look at. The reliability has to be 0.080 or better. So 80% of the time it's reliable. And it should be the test that you're using. See, this is what you're doing in assessment class when I told you you have a person in front of you, you did an intake on them, and then you have to select an assessment tool. That's essentially what you'd have to do for a case that would make it to court, okay? They want to know, why did you pick that? Why, and what relevance does the assessment tool have to the psychological construct that you're looking at, and also to the issues in the court at hand. So for an example, if you choose an assessment tool to look at the emotional trauma that a child has during a divorce situation, and then you're trying to decide what parent would be best for placement, the court is going to look at what kind of tool you use, what kind of assessment tool, and why, and how relevant that is to the case issues, the evidence issues at hand in this particular case, and also how the tool is used in the scientific community. So if you get on the stand, you might be grilled on all of those things. So when you use the test, you have to administer it properly, and that usually for all the tests they tell you how to administer the test. They're very, very specific. They're super specific. They'll even tell you use a pencil instead of a pen, or that kind of thing, and what you do with erasures, or how people change their mind, or what they're doing, all of the surrounding things that they're doing while they're actually taking the test. So that can become important too. And also, is it applicable to the population? So sometimes there are tests that are only to be used for people with developmental disabilities, or people with this IQ, or people with this diagnosis or that diagnosis. So sometimes in court they will ask you that too. Sometimes they'll actually ask you to compare the objective test or the assessment tool that you're using to actuarial tables and actuarial data. So it's good to have both and to know both. And you have to also look at the response style of the person. What are they doing while they're taking the test? Are they distracted? Are they focused? Are they, edgy, nervous, anxious, whatever? They want to know that as well. And they'll also ask you about malingering. Is someone trying to fake the results of the test? Either fake good, because they don't want anyone to think that they have a mental illness, or that they have something wrong with them if someone's trying to get them committed or something like that, or fake bad, where they're trying to get disability or something like that, welfare fraud or something like that, some kind of fraud, counterfeiting, or that they have a mental incapacity to understand something, so that's why they committed the crime, because they didn't have the competence level or something like that. So malingering, we will have a test, an assessment tool for malingering. The most famous one, it's called Tom, Testamental Malingering, and you'll receive that as well. So you have to also be aware of the codes of conduct and ethics that exist around assessment, okay? So we will go over all of those things in great detail as well. You also have to make sure that you don't fall into a trap with things that could compromise your level of expertise. Make sure you're very anal about proper data collection, informed consent, confidentiality, duty to warn, protect potential victims, maintain the test's integrity. So you will have to make sure that you do all of that all of the time, because you want to make sure that you have a reputation for being very thorough, and the courts really will respect that, and therefore they'll come to you when they have questions. I'm going to continue this on part 2 of court issues.